This case starts off looking routine, but within seconds, it turns into something much more serious. A defendant is asking for more time. Sounds normal, right? But here's the twist. Behind this simple request is a string of alleged violations, missed alcohol tests, and a judge who's clearly not convinced. The defense is trying to paint a picture of responsibility, a man with a job, a sick mother, and a family depending on him. But the prosecution? They're raising red flags about public safety. So the real question is, who do you believe? Is this a man trying to get back on track, or someone the court can't afford to trust?
Counsel, I didn't know she was taking over for the case. If I can approach with counsel.
Yes.
The corrections report dated July 16th, I believe.
Yes.
To the bench. And I know that defense counsel already has their own copy. It does address some violations of the conditions. We wanted to bring that to the court's attention.
In Your Honor, I have spoken to my client about this progress report, and Mr. Zinwelski does acknowledge some difficulties complying with the sober link. We discussed the importance of being in compliance with the sober link, and he is willing, if the court is inclined, to go on a scram tether for heightened monitoring, and just to kind of make it so that he's not having to test at the specific times. And then he also has indicated to me that he does have a previous AA sponsor that he's worked with that he plans to reach out to. But he has a good job. And
this is a classic defense strategy, humanizing the defendant. Notice how the attorney emphasizes his responsibilities, a stable job, a sick mother, and a child to care for. These details aren't random. They're meant to show the judge that this man has strong ties to his community and reasons to stay compliant. But here's the tension: emotional appeal versus hard evidence. Courts don't just look at personal struggles, they look at behavior. And if the record shows violations, those personal factors might not carry as much weight. So now the pressure builds. Will the judge prioritize compassion, or focus strictly on compliance and risk? White right pointing backhand index. What do you think matters more here, his responsibilities or his actions?
There was a blood draw, and that was 0.181. I would also let the court know that the defendant has a prior high BAC conviction from April 28th of 2014 in the 15th District Court. It could not be used for enhancement purposes. And the court's already aware of the community corrections report. And those are reasons that would pique our concern for the defendant remaining out at this time. He does present a danger to himself and others based on the most recent tests with the corrections.
And Your Honor, I would just ask that he be allowed to be on a scram tether. I know that he has not been in compliance. He did, after the positive test, he did go and get an ETG test. Those results have not been made available yet. They're still pending. But he believes that he can be compliant with a scram tether, and he does have a job that he works every day, and so he's worried about losing that job. And he also, like I said, he has people that depend on him. He cares for his mom, who's sick. And
so is he saying that he didn't do this? Or this is not, I mean, I thought he was saying that there was this violation of the alcohol.
He believed that the positive test may have been inaccurate, but he was unable to get the ETG test results in time. And then for the miss.
When did he do an ETG?
On July 10th.
At Community Corrections?
It was through an urgent care.
Urgent care?
He said his previous attorney told him to go there. It was at an urgent care. But like I said, he has not received those test results. And as for the missed tests, he does acknowledge that he missed those windows of testing.
According to this, though, he made it 6 days from the time of his release, really 5 days.
Before the first violation.
But he's saying these violations, I mean, I get, counsel, what you're telling me, but is he saying he drank or didn't drink?
Here's where things start to unravel. The defendant clearly says, "I did not drink," but moments earlier, the reports show positive alcohol readings and missed tests. That's a major contradiction, and judges pay very close attention to this. In legal terms, credibility is everything. If your explanation doesn't match the data, your entire defense starts to weaken. The judge even points out inconsistencies in the testing timeline, which makes the situation worse. At this point, it's no longer just about whether he violated conditions, it's about whether he's being truthful. Whitewright pointing backhand index, be honest, does his explanation sound believable to you, or does something feel off?
At 9:19 p.m., he blows a .021.
Yes. And then, is that when it turned off?
Mm-hmm.
Then he indicates that the machine turned off, and he thought
The what?
the machine turned off.
He knows he's supposed to do a compliance test when it comes back every 15 minutes.
Yes, Your Honor. And it's a compliance test sent, and then pushed okay, and the machine shut off at that time. That's all I know. And then I woke up the next morning and they found out that was they were blowing. And then after work, I went and got the ETG test as soon as possible. And thereon, I was talking to the previous lawyer, and she got all the emails that I had trying to track this down, but they just haven't got it back yet.
Well, then somebody's going to have to get those to me somehow or another. But at this point,
If I could just be able to continue working, and as soon as I get those results, I would personally come bring them to you or whoever I would need to. But I just would like to change.
here's the problem. What you're telling me about the testing doesn't make any sense. And about the compliance test. Because you don't do another test after the 9 p.m. test. You don't do another test until almost 12 hours later.
Well, because after the 9/17 one, when I had me reblow, is when it said compliant test sent, and I just pushed OK, and the machine turned off. That's all I know. The first one did say retest, and I did that at 9/17, and it came up saying compliant test sent, and I pushed OK.
And as I indicated before, he would be willing to go on a scram tether for heightened monitoring, with the understanding that he would be constantly monitored.
Yeah. What he's telling me doesn't make sense when I'm looking at the court. Defendant's bond.
And just like that, the judge makes the call. Bond revoked. This means the defendant is going back into custody, at least until the next hearing. Why? Because from the court's perspective, the story didn't add up. The inconsistencies in testing, the missed compliance steps, and the prior history all stacked against him. In situations like this, judges have to think about public safety first, and here, the risk was simply too high. This case is a powerful reminder: when you're out on bond, every condition matters. One mistake, or even one unclear explanation, can cost you your freedom. If you found this case as intense as we did, hit that like button, drop your opinion in the comments. Do you agree with the judge's decision? And don't forget to subscribe for more real courtroom breakdowns.